I'm ready, Your Honor, whenever you're ready.
Okay. What about the pretrial? You ready on that as well?
Yes, ma'am.
Okay. Tate Daily sentencing, Mr. Kindler.
Mayor.
Good morning, you're Tate Daily.
Yes, ma'am.
And Mr. Daly was previously in court, entered a plea of guilty to driving while intoxicated with a child passenger. I've received the pre-sentence report.
A quiet courtroom morning takes a sharp turn when the judge begins sentencing a man whose choices nearly ended in disaster. What starts as routine paperwork quickly reveals the weight of guilt, consequence, and second chances. But just as the room settles, the real tension hits at the midpoint.
Has everyone had an opportunity to review that report?
Yes, Your Honor.
State has, Judge.
Are there any additions or corrections?
No, Your Honor.
None from the state, Judge. The state would just ask that the court follow the recommendation.
Well, this could have been bad, couldn't it?
Yes, ma'am.
All right, so I'm going to find Mr. Daly that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of driving while intoxicated with a child passenger. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but I'll probate that. You'll be on probation for 5 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. That is going to include entering and successfully completing the JCDI program, which is an intensive outpatient treatment program. You will be required to have an auto ignition interlock device on any vehicle that you drive and comply with all the other conditions of probation. If you do that, then for all practical purposes, your case here in court is over and you'll be able to serve that 2-year prison sentence while you're out on probation. The other side of that, however, is if you violate any condition of probation, you can be brought back into court and you could be facing that 2-year sentence that you've already agreed to. Do you understand?
Yes, ma'am.
I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler. And the state is going to dismiss the other, is that correct?
Judge, my intention, the state's intention was that they run concurrent.
Can I see that pre-sentence report again? Did we?
Yeah, all right.
She's,
I got a copy of it.
I only know this
the one
morning.
I just did. Yeah, the plea was,
I misspoke, Judge. I'll dismiss 0180.
yeah, that was at the,
It's whatever the paperwork reflects.
yeah, that's what the paperwork
Yes,
is. I
ma'am.
think. Okay, all right. I will sign a dismissal in 25 DCCR 0180. You need to have a seat here in the courtroom. Probation's going to call you up when she's ready to go over your paperwork.
Yes, ma'am.
Good luck to you, sir.
I'll leave it to you. Yes, okay.
And then Desiree Kirks, 2 cases.
Judge, I think it's just one case.
Oh, it is. It just showed up twice. You're right.
It has the same
Cause number and,
cost number, and it's like a double.
that's weird. Well, and it's even on the,
Kind of short.
it's in Odyssey that way.
So far, the court has moved through guilty pleas, probation terms, and warnings that carry life-changing consequences. Each defendant faces a crossroads: freedom if they comply, prison if they slip. But from the midpoint forward, the stakes rise as addiction, criminal history, and fear collide in the judge's next cases.
Too. What?
I'll blame Odyssey. There you go.
All right, ma'am, you're Desiree Kirks. And in cause number 24 DCCR 0518, Ms. Kirks is charged with deadly conduct, discharging a firearm, set for trial Monday, December the 1st. And what is the announcement?
Ready? Say Judge.
All right, then I will number the case. It's obviously one of the older ones. I do have a case that's already been set, especially. I can't imagine this is something that would be a very long case, correct?
It wouldn't be, Your Honor. It's
If-
deadly conduct.
Just if there's a possibility that Judge Thorne could hear it, would that be an option?
I would have no problem with that.
Okay, I'm gonna number it and just see if that's an option, just based on the fact of the level of this offense and the other ones that we have. I feel like we're gonna have a hard time getting to it if I don't do something like that. So I'll let you guys know when I number it.
So you want her back here on the first?
I'll let you know. Stay in touch with Mr. Kimler, and he will let you know if you need to be back here or potentially in another court for your trial. Okay? And sentencing on Daniel Ibaro. Okay, you're Daniel Ibaro?
Yes, ma'am.
And Mr. Ibarra was previously in court, entered pleas of guilty in cause numbers 24 DCCR 1722 and 24 DCCR 2289, both theft of properties. They were enhanced to second-degree felony offenses with caps of 10 years in each of those cases to run concurrently as the agreement. Is that correct?
Yes, Your Honor.
I've received the pre-sentence report as well as an update report that just has some more specific information from criminal history from Spokane, Washington. Did everyone get that?
Yes, Your Honor.
Yes, they did.
Are there any additions or corrections to the pre-sentence report?
No to the offense, Your Honor.
Not from the state.
All right, Mr. Kimler, you may proceed.
Your Honor, PSI reflects extensive criminal history on Mr. Ibarbo, which I suppose the court could infer from the fact that two misdemeanor theft cases can be enhanced up to second degrees, which implies that he does have extensive history. The facts of these two cases are both, as the defendant indicated in the pre-sentence report, that he was under the influence of methamphetamine at the time both were committed. It's not offered as any type of exculpatory evidence or even perhaps mitigation, but it does kind of explain why somebody with this criminal history would be doing what he's doing with a laundry basket and then some items from Walmart, all of which were under, I think, probably the Class B range of the theft. I would observe that there appears to be $300 in restitution payable on one of the cases for the laundry basket. Obviously, methamphetamine, drug addiction, but for that, I think Mr. Ibarbo wouldn't have been doing these types of boneheaded thefts. He's recognized that, and in counseling with him, he's done at least what I asked him or suggested that he do, and that's to go into an inpatient rehabilitation program, drug rehab program, to try to address the substance abuse issues that he suffered from really an early age, which is indicated in the report, in the pre-sentence report. That's been an ongoing thing almost his whole life, and I think he's done that, and he's I don't know if you could say terrified of going to prison, but certainly he doesn't want to go to prison. And I think he's willing to do what he needs to do to stay out of prison, to comply with any terms of probation that the court assesses. He indicates to me that he is drug-free, which obviously if he drug tested him this morning, that could be corroborated. Or not, if he's not drug-free this morning, I don't know. But I assume, I would hope that he is. And he would just like to address the court perhaps better than I, more articulately, to explain his position and why he thinks that probation is appropriate.
Are you wearing a drug patch?
No, ma'am, Your Honor, but I've been clean sober since July the 8th.
Have a seat in the jury box. Let's get that checked first. Mr. Chavarria, are you ready on Brian Tipton?
Yes, sir.
Come on up. All right, sir, you're Brian Tipton, and this is 25 DCCR 0149. Mr. Tipton was previously in court, entered a plea of guilty to the state jail felony offense of solicitation of prostitution. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, sir.
We have, Your Honor.
Any additions or corrections?
No, sir.
Not from state judge.
All right, Mr. Tipton, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney's office and defer all proceedings and place you on probation for 3 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. If you do that, then this is an excellent opportunity because you do not have a felony conviction on your record. And if you successfully complete the probation, at the end, the case will actually be dismissed. You'll never have a felony conviction. The other side of that, however, is if you violate any condition of probation, you can be brought back into court and you could be found guilty of the offense and sent to the state jail prison for up to 2 years. Do you understand? I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. You just need to have a seat here in the courtroom. Probation will call you up to her desk when she's ready to go over your paperwork. Yes, sir.
One request, Your Honor.
Yes, sir.
On the recommendations,
Let me see it back, please.
and I believe it states an agreement, Your Honor, but on supervision plan item number 2,
Oh, I might need, what is that?
It's curfew.
it's correct.
Kristen, can I see,
I have it.
that's okay, she's good. Thank you.
Yes, Your Honor.
Sorry. All right, go ahead.
On supervision plan recommendation number 2, be inside your home every day from 10 p.m. to 6 a.m. except for employment purposes. We're requesting that we add in addition family-related medical emergencies to that, Your Honor.
Okay. Is there some anticipation that there would be something?
Yes, Your Honor. It's my understanding that the probationer defendant's wife has had some incidents in the recent past, and it is likely and very possible that they happen in the next few months. And so we just want to make sure that the probationer is successful and that he doesn't unintentionally have any issues.
So on the curfew, it'll be except for employment or family medical emergency.
Thank you.
Yes, sir. All right, just have a seat. Probation will call you up in just a minute.
Thank you, Your Honor.
Thanks.
Courtroom opens in steady rhythm, but beneath the calm lies a series of lives about to be reshaped. The first major turning point comes with Tate Daily, who admits guilt to driving intoxicated with a child passenger. His sentence, 2 years in state jail, probated for 5, hangs like a warning. The judge's voice remains steady, yet the message is sharp. Follow every condition, or face the full weight of the agreed-upon sentence. With firearms restrictions explained and paperwork handed over, Daily leaves with both a chance and a burden. Next comes Desiree Kirks, charged with deadly conduct for discharging a firearm. Her case appears twice in the system, an error that adds a flicker of confusion to an already tense schedule. The judge moves swiftly, considering logistics to ensure her trial is heard despite a crowded docket. Kirks stands quietly, waiting to learn which courtroom will decide her fate. But the emotional center of the second half belongs to Daniel Ibaro. His history is long, bruised by addiction and repeated theft. 2 low-level thefts, committed while high on methamphetamine, have escalated to second-degree felonies due to prior convictions. His attorney paints a picture of a man battling lifelong demons, terrified of prison, desperate for change, newly entered into drug rehabilitation. The judge listens, then orders a drug patch check, signaling that hope must be proven, not promised. Finally, Brian Tipton steps forward for sentencing on solicitation of prostitution. The agreement grants probation instead of a felony conviction, an extraordinary opportunity. Yet, even here, life's complexity intrudes as his attorney requests curfew exceptions for family medical emergencies. The judge agrees, balancing accountability with compassion. By the end, the courtroom feels transformed, a place where choices collide with consequences, and every sentence becomes a mirror reflecting who each person decides to become.